appeals Sienkiewicz against Greif and Knowsley Metropolitan Borough Council against Willmore.
Here's the court, my lady and my lords. In these two appeals, I appear with my learned friend Mr. Feeney for the appellants. In the appeal where Greif are the appellants and Mrs. Sienkiewicz is the respondent, my learned friend Mr. Melton and Mr. Pearce appear, and they are directly to my left, to your right as you look. And in the Willmore appeal, my learned friend Mr. Allen, who sits next to Mr. Melton, appears with Mr. Covington. Before I start on the substance of the appeals, the court will know that both Mrs. Costello and Mrs. Willmore died of mesothelioma, which is a particularly unpleasant terminal tumour of the pleura or the peritoneum. I know that members of the families are present, and I am certain that all present must recognise that in talking about mesothelioma and its consequences, the consequences that matter most to those who are most closely involved are that they have been deprived of someone who they loved, whether as a mother, a wife, or in any number of ways. So while we talk dispassionately about the legal consequences, I, on behalf of those at the bar, can only ask for the family's understanding and tolerance as we debate the issues before the court, and can only assure them that we understand that for them this is more than just a legal issue. The proposed course of my submissions, subject to any direction from the court, is that first of all I propose to say a little, but not very much, about mesothelioma. I then propose to spend a little bit of time on the terminology of causation, because in my respectful submission, even now, there is a lack of clarity about what certain key phrases have meant over time and now mean either in the context of the Fairchild exception or generally. Having done that, I was proposing to move on to what I call issue number one, which I would express as follows, leaving on one side the effect of Section 3 of the Compensation Act. Does Fairchild, as explained or extended by the cases that have followed it, lay down a rule of law that in cases involving mesothelioma, a claimant can
Sorry, can you just go a little bit slower? Lay down a rule of law.
That in cases involving mesothelioma, a claimant can always satisfy the law's causal requirements by proving, and only proving, that the defendant's tortious exposure has materially increased the risk of the victim contracting mesothelioma. The second issue that I would then wish to address is what is meant by the phrase material increase in risk in the context of the Fairchild exception. The third issue I would state shortly as follows. What is the effect, if any, of Section 3 of the Compensation Act upon the causal requirements that a claimant must satisfy in a case of mesothelioma? And then as issues 4 and 5, I would wish to make submissions about what would be the result of the application of the relevant principles in the case of Sienkiewicz, issue 4, and issue 5, what should be the result of the application of the relevant principles in the case of Willmore. And the context for all of these submissions, in each case, on any view, is that the exposure to asbestos, for which the defendant has been held responsible in tort, was very light.
So which was? So what was?
Was very light.
Sorry, what? I missed the first. The exposure.
The exposure to asbestos, for which the defendant has been held responsible in tort, was very light. The facts which have been agreed and set out in the respective statements of facts and issues are shortly stated. The facts in Sienkiewicz are in the Sienkiewicz core bundle at tab B, pages 1 to 7. And although the case bears her daughter's name, it concerns Mrs. Costello, who died in January 2006 at the age of 74 of mesothelioma. She had worked for the defendants and their predecessors at their factory in Ellesmere Port in Cheshire between 1966 and 1984. The trial at first instance was tried by His Honour Judge Mayne, and he gave judgment in November 2008. And as we shall see when we look at the judgment rather later, he found that the exposure to which Mrs. Costello had been subjected was very much less than had been initially alleged by the claimant. My lords, the facts as set out in the statement of facts and issues are at pages 2, 3 and 4, and I do not know whether you wish me to read such things out. I take it that the facts are known. Yeah. Similarly with the facts in Willmore, which again in the core bundle are at tab B. With that indication, I think I need only say, for those others listening, that Mrs. Willmore was born in September 1960, and she attended secondary school known as Borough Comprehensive between 1972 and 1979. She developed a mesothelioma which was diagnosed in 2007 and which caused her death in October 2009. One of the peculiar factual quirks of this case is the development of the allegations about where she may have been exposed to asbestos. So one of the features of this case was that, as a matter of fact, she made an application under the Pneumoconiosis Workers' Compensation Act 1979 and received a significant award on the basis that her mesothelioma was caused by exposure when working in the Army and Navy stores in Liverpool. And the statement of fact sets out how her allegations of exposure changed, and she finally settled on the time that she was at secondary school, the newly built secondary school at Borough Comprehensive, and that was the basis of the trial and the findings that were made. In one material respect, each of these cases differs from the previous cases that have reached the House of Lords or the Supreme Court. Because both Fairchild and Barker, in both Fairchild and Barker, there was no doubt that each of the tortious exposures at issue were sufficient to have caused the mesothelioma, even though it was not certain that they had done so. In these appeals, a prior issue is raised, which is whether or not it was reasonable to conclude that the tortious exposures were themselves sufficient to have caused the mesothelioma. The appellants have set out submissions relating to mesothelioma and medical causation in section 2 of the case, which starts on page 2. And what I hope to do is not to read out the case on the assumption that that has been read already,
Yes.
but to develop points that appear there and highlight points.
I'm sorry, I'm rather lost here, Mr. Smith. You say there was a prior issue here where the tortious exposures in these respective cases in themselves were sufficient to cause the
Could be
mesothelioma.
sufficient, yes.
But I'm sorry, I thought on the facts, that case was decided against you, wasn't it? I mean,
Well, in Willmore, it was decided in our favour, in the sense that it was decided that the exposure was not the cause of the mesothelioma. What was the judge's finding?
yeah. But I mean,
That doesn't prove the converse, that it couldn't have been.
It doesn't prove the converse that it couldn't have been. And we come straight up against where I submit the difficulty of these appeals lies, which is that it is accepted on all sides that every exposure to asbestos over and above ambient exposure causes some increase in risk, because it has been found that the risk of mesothelioma is dose-related. But it does not follow, in one sense, as soon as you say it increases the risk, and therefore, for example, you say that instead of 24 per million, there is a risk of 25 per million, it follows from that one more person per million may die as a consequence of an increased level of exposure. And so in that sense, one can say that there is the possibility that any additional exposure can cause death. But it is also, there remains the issue as to whether or not a particular exposure is of itself de minimis, so that the increase in risk is so small that it is not right to attribute the happening of a mesothelioma, either in a given case or generally, to that very small incremental.
well, that I follow entirely, but I mean, if you just put it in terms of was the exposure sufficient, the answer is on the evidence, as I thought was indisputable, yes, because, as you say, a fibre can do it. I mean, which issue of the pleaded issues do you suggest this is? Because I don't follow this. I don't see this as a separate issue. I mean, I'm just looking.
It's a material increase in risk, isn't it? It's the second one.
The issue is, yes, it's material increase in risk.
No, that's a different question, though.
But my lord, in the way that my lord puts it, in the way that I've accepted by my clarification, I agree that, in theory, every incremental exposure increases risk, and therefore, in theory, increases the prospect of either an individual or in a population of more people dying. And that I accept. What we are concerned with directly is the legal attribution of cause where the increase in risk is very small.
I'm sorry, I'm not sure that I understand in what respect you say these two current cases differ from the two earlier cases on the question of whether or not, to use your language, the tortious exposure in each case was sufficient to cause mesothelioma.
In the majority of cases that have come before the courts thus far, the typical case has been of substantial exposure, and Fairchild was just such a case, where each of the victims had been successively exposed by a number of employers to substantial exposure. And no one could take the point there, even in a multiple case, that any individual tortfeasor's contribution on its own, if the mesothelioma had happened and that had been the only exposure, none of them would have said, well, my exposure is so slight that you shouldn't say that my exposure has caused the mesothelioma. And if you take that back to an individual case, because there are individual cases or there are cases of mesotheliomas with individual or sole exposures, of which these are two, in many cases, it goes without saying that the level of exposure is such that it is reasonable to attribute the mesothelioma to that exposure. And the case which claimants frequently rely upon, a case called Brett against the University of Reading, is just such a case where it was held, or was a case where it was held. Sorry, I've got that wrong. The question is whether in all cases of mesothelioma, however slight the exposure, in a single exposure case, it is inevitably to be concluded that the mesothelioma is caused by that incremental exposure. So the difference between Fairchild and Barker and these cases is that the level of exposure was such in Fairchild and Barker that no tortfeasor was able to say, well, my exposure was so slim, so small that I should be left out of account.
What I don't understand is whether you're viewing material in absolute terms or whether it's by reference to whatever else happens to be the exposure from other sources. Let us suppose you had a case where there were 5 potential candidates for exposure, or maybe 6. Each of the 5 was for 18%, and that leaves another 10%. Right. Would you then argue that none of those was material because 18% is a very small number?
No.
Or would you then simply be focusing on the 10% and say, well, he doesn't contribute, all the rest pay 100% and then share, theoretically, between themselves?
The answer to the easy answer to the question that was halfway through that is no. I would not be saying that simply because it's 18%, no, everybody can.
So it's not absolute.
It's not absolute. No. In the multiple exposure case, various proposals have been made. So we have recorded in our case our understanding that, for example, Dr. Rudd, who is one of the preeminent authorities in this area and who appears in very large number of these cases, would say that you can't say that an exposure in a multiple exposure case is to be ignored unless you can show 2 things. One, that it on its own would not increase the background risk by more than a factor of 2, and it on its own is only 1% of the aggregate exposure. So those are very demanding criteria, but that is his expressed view. it would be something to be decided on a case-by-case basis, on the basis of evidence in future, whether or not, or where, in multiple exposure cases, the line should be drawn. We have the advantage of operating in a slightly simpler environment of single exposure cases. And what we propose is that, well, first of all, as my Lord knows, our proposal is that you can, in fact, decide such cases simply on conventional principles, as Judge Mayne did. But we also propose that if one looks at if one is applying the Fairchild exception, because I accept that Willmore was treated as a Fairchild case below, and therefore should be treated as a Fairchild case here, that the touchstone for material increase in risk should be that it increases the background, or would increase the background risk by a factor of 2. Not with absolute mathematical precision, but as a guide for the court. And the reason why I say not with absolute mathematical precision is that one cannot typically calculate exposures and predictive risks with absolute precision. So, as has been done in other jurisdictions, if that sort of exercise led to a conclusion that the exercise led to an outcome which was near to a relative risk of 2, the court could take that into account and saying, well, this is a material exposure. The problem which my lords face, and which I face, is that the words significant and material are of themselves infinitely elastic. And in the context of contributing to risk, there is no other obvious staging post between no contribution to risk at all and increasing the relative risk by 2, which would be taken as a conventional staging post for the attribution of causation and liability.
But I'm sorry, it's rather different from the ordinary causation approach, because, I mean, you're saying unless it's twice the background, it's not material. That's the proposition, as I understand, you're putting forward here. Is that right?
I'm putting forward 2 propositions, my lord. One, a single exposure case can be decided on conventional principles, and in doing so, looking to see whether the exposure has increased the relative risk by a factor of 2 is a material exercise which was undertaken by Judge Mayne and properly carried out by him. That's one. Material increase in risk in mesothelioma cases really comes into focus in cases of multiple exposure, because it is the test that was adopted in Fairchild and in Barker for the attribution of liability through the mechanism of causation. And in relation to multiple exposure cases, so cases which we accept are within the Fairchild exception, we submit that it remains the best test is to look to see whether or not the exposure at issue would have increased the relative risk from the background exposure, which we all have, by a factor of 2.
I mean, just looking at Sienkiewicz, I mean, Mrs. Costello, I mean, she might have had 2 employments which each increased the risk by this very small amount. Each of them increased the background risk by 18%. You would say, I mean, that's not a single exposure case. How does it play then? They're neither, you can't say, well, look at it as simple causation. You say then, What, that they both fail the test of materiality?
Well, the 18, if it only increases the predictive risk by 18%, it is so far short of having, of itself, increased the relative risk by a factor of 2, because it would have to get up to 100% to increase by the relative risk by a factor of 2. That the court should conclude that that exposure was not material. And in Mrs. Sienkiewicz's case is quite a good example, because the background risk itself is very, very slight. And so you would be talking in each case of an increase in the predictive risk of 18%, of something which was itself a very slight risk.
Let's suppose we had 6 people, each of whom increased the background risk by 18%. Then if you viewed the 6 people together, the background risk would have doubled. Would you accept that that would have to be done in that situation, and each of them would be 100% liable, or do you say that you pick them off individually and say that none of them has done anything significant?
I look at them individually, Michael, for this reason. What the court is concerned with is imposing 100% liability upon individual tortfeasors. And two things are known about a multiple exposure case. One is that current medical science cannot pinpoint which was the cause. The other is that you may well have multiple exposures from people who are quite unrelated to each other, where each individual's tort was of an immaterial extent. So that if you could either stop the clock or could view it in isolation, you would say that although there has been proved a breach of duty, this exposure was so slight as to be immaterial.
But isn't this falling directly into Lord Hoffman's problem of it being a chance as to whether you're employed by one employer or by more than one? Because you would have to accept that if you were only employed by one employer and it increased the risk by 120%, it would be liable in full. Whereas if the employer was clever enough to restructure itself every other year so that a different subsidiary employed the unfortunate employee, none of them could be said to be responsible for more than 18%.
Absolutely right. And and that is a question where the court has to decide whether one is going to maximize the difference between the Fairchild exception or keep some link between cases in the Fairchild exception and normal conventional rules of causation. And that is a straight choice which the court can make. And the reason why I say this court can make it is because, as Fairchild and Barker have demonstrated, we are in an area driven by policy, we are in an area driven by considerations of fairness, and when one looks at the balance as between claimant and defendant, the balance in our respectful submission is different if the defendant is able to say, I was in breach of duty to you, but the exposure to which I subjected you was so slim that it would not have increased the background risk to a material extent. Now, the proposition for the other side is that even if you can say that, and even if you can establish it, you should be held liable under the Fairchild exception with the consequence that you are held liable to the extent of 100%.
Well, it all depends on what you mean by material.
Well, I agree with that.
And you're suggesting that, as I understand it, something of the order of doubling the risk.
The background risk.
The background risk.
Yes.
And so, I mean, in a sense, that's critical, because if materiality is, in this context, is a fairly flexible tool, then I think you would be saying, as a matter of policy, it can be fixed where the court, as a matter of policy and fairness, thinks it ought to be fixed.
Yes, exactly. And precisely so. The problem is that material increase in risk of itself means nothing. If one acknowledges, which all the cases, or all the old cases which referred to material increase in risk or material contribution to injury, always, you will find the contradistinction with something which is de minimis. And the choice, effectively, that the court has in these appeals is either saying, well, any exposure to asbestos will do, either within or outside the Fairchild enclave, or some meaning has to be given to the word material and some meaning has to be given to the words de minimis, because you cannot simply define them by reference to each other, because that's circular in this context. And so...
So you are simply proposing, as it were, off the top of your head, the ambient level of exposure is very small. There's a very useful measure of what is de minimis. If it's below what's there anyway, it's de minimis. If it increases what's there anyway by more than 100%, then it's no longer de minimis.
Yes. Because that, not off the top of my head, my lord, we go back to a principled approach to causation, which is employed in other areas, where the use of an increase of relative risk of 2 is now conventionally taken as demonstrating, or proof by proxy, that the event occurred or did not occur as a consequence of the factor which is being investigated.
But that's simply a balance of probability approach, isn't it? If the particular cause has more than double the risk, and you've got to choose between the two of them, then the new cause, if you like, is demonstrably more likely to have been the cause than the original.
In our first issue, if my lords accept if the court accepts my first issue, namely there is no rule of law and therefore single exposure cases are susceptible to proof on normal principles, then an increase in relative risk of 2 is balance of probabilities, or is a factor in determining a case on the balance of probabilities. Yes. In a multiple exposure case, it isn't, because it's only a threshold argument to get you into the Fairchild enclave. All you will need to show, and in most cases, or many cases, in any case of laggers or carpenters probably, the question simply won't arise. But if you were to have a Fairchild case, a case within the Fairchild enclave, to be one of the exposures that is to be regarded as potentially contributing and therefore potentially having 100% liability imposed upon it, each of them simply has to be shown to increase the background risk. Not the risk of everybody else is imposed, but the background risk, the ambient risk. And we submit that that is not an unreasonable threshold.
I'm trying to understand where exactly does increase in risk fit into the conventional approach to causation? I mean, I thought the conventional approach was, you said, on the balance of probabilities, did this cause the injury? And the problem in McGee and Fairchild and so on was you couldn't say that because they have... So you changed the rule and you said it was enough that to increase the balance of probability, not because... But you didn't conclude from that that on the balance of probabilities it was more likely to be the same. You just chose a different rule. And that is, now, how does that fit into your submissions? I'm having difficulty with this. When you refer to the conventional rule and then you talk about the increasing the risk by a factor of 2 and so on.
The way it fits into my submissions, again, I need to distinguish between what I say should apply in a single exposure case and in a multiple exposure case.
Yeah. Yeah.
In a multiple exposure case, the court has to show, and the court has to show, that the come away from mesothelioma to any other sort of case. Let us take a case of another industrial disease. In a case where conventional rules apply, it is conventional to look as part of the evidence, or possibly even all of the evidence, the fact that it can be shown that an exposure or an event has increased the risk of the outcome by more than 2. And we have examples in the authorities bundles, which I will take your lordship to later on. And it is now conventionally, certainly in the lower courts, accepted that if you demonstrate by appropriate evidence that the defendant's behaviour has increased the risk of the outcome by more than 2, then on conventional principles you win, because the court is satisfied that the defendant's behaviour probably caused...
So, fine, let's take an example. Supposing that it doubled it from 10% to 20%, chances of it having been caused by this. Is that enough?
In a conventional case?
Yes.
Yes,
So even though you can only conclude there's a 20% chance that this caused it.
Yes, because the background risk will typically be expressed in X per million or X per something or other. And so what is increased by 2 is X. So if the risk as a consequence of the defendant's behaviour is 2X per million or 1,000 or whatever it may be, where previously it was X, then the court will be satisfied that it was more probably than not the defendant's conduct that caused the outcome.
If you're only looking at if you've only got the 2 runners, but if you've got 4 other runners, then that doesn't follow.
That's why I am trying to keep the distinction between what I call the single exposure case and the multiple exposure case. I do not propose, because it would be straight contrary to Fairchild and Bark, it would be contrary to absolutely everything, and I wouldn't have the courage to propose it, that in a multiple exposure case, particularly in mesothelioma, it would have to be demonstrated that each tortfeasor's exposure doubled the otherwise existing risk overall. Because that would be going back to saying you have to prove on a balance of probability, which is precisely what Fairchild, the inability to do that is precisely what Fairchild is founded upon. But what we are proposing is not at that stage, but at an earlier stage, when you are deciding which exposures should be taken into account in the Fairchild enclave or the Fairchild exception, you have a prior threshold, which is that if you can't show that even viewed on its own, a defendant's exposure would have increased the background risk by a factor of 2, then it is not reasonable to bring it in to the consideration of the Fairchild exception.
The problem I have with that is that you seem to be applying probability in a context where, because the background risk is infinitesimally small, one is anyway dealing with a situation where, in a sense, lightning has struck, i.e., a very rare risk has materialized. Now, is it really then sensible to judge whether it's materialized from the background or from the also very slight additional risk contributed by your clients on a balance of probability in the way you're suggesting? It seems to me rather odd.
Well, in one sense, my lord, I am not qualified to answer that question. But what I can say is that it is an exercise which has been undertaken both by claimants and by defendants. It is an exercise which is undertaken in other realms as well as mesothelioma. And it is, if you like, a question of fact in any given case, whether the evidence is too difficult
Well, can I just, I mean, I see that argument, but let us just suppose you're treating background atmospheric exposure as if it's something special. There seems to be an argument that actually it's just it's pollution, which ultimately is to the book of humans, but perhaps not entirely. Let us suppose, however, that the only possible causes of exposure were, and this seems to be the basis on which Fairchild was approached, were two employees, one of whom was responsible for the same level of risk as atmospheric exposure gives, and another of whom had contributed an additional 18%. Would you say then that you'd apply your test, you'd be straight up against Fairchild, wouldn't you?
No, I wouldn't. On the test that I'm proposing, the court would conclude that it was probably, or that liability should attach to the person whose exposure doubled the risk, but that the person who merely increased it by 0.18, 18%, should not be included.
Yes, I was really asking you to ignore atmospheric risk as it seems to have been ignored in the past.
I was trying to ignore. I mean, I was trying to, as it were, to translate it to a different disease which has all the same characteristics as mesothelioma, save for ambient exposure. And my Lord will know that it is part of our submission that ambient exposure is indeed part of the Book of Humans and should be left out of account when considering whether or not to apply the Fairchild exception.
Mr. Smith, Barker, on the face of it, extended the Fairchild exception to put many more cases in the enclave, as you've described. Is that right?
Well, it extended it to one contributory negligence. There are two dicta, one from my Lord Hoffman and one from my Lord Scott, which we will definitely look at and can look at now if you like, which have been taken as going much wider. It might be helpful to look at them straight away.
Well, but just pause a moment. I mean, just assume that it does extend it. It was extended on the basis that actually in this wider enclave, you only were responsible for the aliquot portion, the increase in risk that you represent. Parliament, as we know, then changed that. But it seemed to me still open to you to argue, and I'm just really wanting to know whether or not you are arguing, I rather hope you are, that actually, in the light of what happened in Parliament, the court ought to, so to speak, row back from the Barker expansion of the Fairchild enclave.
I am.
You are? Yes.
Yes. Am I not bad?
I mean, I haven't sort of noticed where in the argument you do advance that, but...
Well, can I go straight there and
I mean, I'm not suggesting it right, but at least we ought to be looking at it.
well, where you will find it in my submissions is in section 3, which is where we deal with whether or not on page 11 of the case. But it may be helpful. Could we start at page 9, which is where we deal with single exposure cases? And our submission is that ambient exposure should be left out of account. We accept in paragraph 3.5 that every resident of the United Kingdom in any industrialised country will be exposed to levels of asbestos, and then we look at authority, 3.6. So far as we are aware, and certainly the respondents have not suggested otherwise, no previous English decision has suggested that a person's inhalation of their normal ambient air is a competing cause. And certainly so far as I am aware, I'm not aware of an authority in in another jurisdiction. 3.7, ambient exposure certainly didn't arise in McGee. 3.8, it certainly didn't arise in Fairchild, and we've cited a short passage from my Lord's speech there, which we suggest implies that my Lord Roger was thinking in terms of events rather than background exposure. And the court knows that in Fairchild, Lord Hoffman expressly excluded the case in which there's only been one significant exposure from the Fairchild enclave. And then when we come to Barker, our submission is that there was no suggestion. As far as I recall, there was no mention, and Mr. Allen will correct me if I'm wrong, I do not believe that ambient exposure was ever mentioned in Barker. And respondents or claimants rely upon two passages, which could we look at now. It's in Authorities Bundle 1. Tab 2. And the passage which is typically relied upon is at paragraph 17. Where Lord Hoffman said it shouldn't matter. Does the court prefer me to read a paragraph out, or it's this paragraph?
If it's a fairly short extract that you're referring to, I think it's better to read it so everybody can follow your argument. If it's something lengthy, then leave it to us.
For paragraph 17, it should not therefore matter whether the person who caused a non-tortious exposure happened also to have caused a tortious exposure. The purpose of the Fairchild exception is to provide a cause of action against a defendant who has materially increased the risk, but the claimant will suffer damage and may have caused the claimant will suffer damage and may have caused that damage, but cannot be proved to have done so, because it is impossible to show on a balance of probability that some other exposure to the same risk may not have caused it instead. For this purpose, and this is the passage that's relied on, it should be irrelevant whether the other exposure was tortious or non-tortious by natural causes or human agency, or by the claimant himself. These distinctions may be relevant to whether and to whom responsibility can be attributed, but from the point of view of satisfying the requirement of a sufficient causal link between the defendant's conduct and the claimant's injury, they should not matter. The first thing to say is that in going as far as natural causes, what Lord Hoffman said was undoubtedly obiter, because the issue was not before him. It is not entirely clear what he meant, because all the discussion in Fairchild and Barker was about what I would call events, be it the defendant sawing his own asbestos board or someone being exposed at work, identifiable what I called untoward occasions. But we submit that that passage needs to be seen in the context of paragraph 48, where at the beginning of the paragraph, Lord Hoffman referred to the fact that the Fairchild, I'll come back to this in a different context later, exception applies only when the disease has actually been contracted. He points to one of my failed submissions, that the claim shouldn't be characterised as causing a risk of the disease. And then he goes on to say, but in cases which fall within the Fairchild exception, that possibility is precluded by the terms of the exception. It applies only when the claimant has contracted the disease against which he should have been protected. And in cases outside the exception, as in Greif and Scott, a risk of damage or loss of a chance is not damage upon which an action can be founded. But when the damage is apportioned amongst the persons responsible for the exposures to asbestos which created the risk, it is known that those exposures were together sufficient to cause the disease. And what we submit in the case and to the court is that if ambient exposure was intended to be relevant to this exercise at all, it too should have been brought into account as a contributor to the risk, because the aliquot proportion of the defendant's contribution to risk would be decreased proportionately. And the fact is that that possibility was not mentioned or adverted to by the House of Lords, and we submit that if that had been the intention to bring ambient exposure in, something would have been said about it. The other passage which is typically referred to, and which was referred to by Lord Clark in the Court of Appeal in Sienkiewicz, is at paragraph 59, which is from the speech of Lord Scott. And I can pick it up at letter B on page 598, just below letter B, where Lord Scott said liability is imposed by Fairchild on a negligent employer because that employer has, by allowing the victim to be exposed to the injurious agent in question, materially increased the risk that the employee will contract the disease or be afflicted by the condition attributable to that injurious agent. The fact that there may have been periods of exposure during which the victim was employed by an employer who had not been in breach of duty, or during which the victim had been self-employed, or during which the victim had not been working for reward in any capacity, does not detract from the exposure for which the negligent employers had been responsible. And my Lord, that is interpreted by the respondents in this case, and by some others, as the phrase during which the victim had not been working for reward in any capacity is taken as encompassing ambient exposure. I submit it means nothing of the sort, and that what it is talking about is another incident such as Lord Scott was talking about in the rest of his sentence, an exposure in breach of duty by an employer or when the victim was self-employed. So I do not accept that ambient exposure was ruled on by the House of Lords in Barker.
Couldn't it simply be referring to a situation, for example, where in your private house there's asbestos lagging or an asbestos lined chimney? Which,
or just doing DIY with an asbestos product?
Yes.
Yes.
Right.
That is our submission. And certainly Lord Scott did not propose, any more than any of the other speeches, that there should be an additional discount for risks attributable to ambient exposure. So then, I will turn straight back to my Lord Brown's point. Having seen the way, which I was going to deal with earlier, but I've short-circuited now, having seen the way that the Fairchild exception grew out of McGee and was then further extended by Barker, our submission is that one has to remember and remind oneself that this is an exception driven by the requirements of fairness. And so we can see how far we have travelled thus far and take stock. McGee, no doubt that the brick dust was the cause of dermatitis. No suggestion of a prior disposition, either congenital or environmental. entirely fair, ruled the House of Lords, and not disputed, that the single employer did not escape liability where the claimant couldn't prove which of the periods with the brick dust on his skin had caused the dermatitis. Fairchild, each employer's exposure was in breach of duty. There was no doubt that the mesothelioma was caused by the aggregation of those breaches of duty. It called for a remedy. Again, no question of congenital or environmental predisposition. And the allocation of liability was between those who were known to have caused the disease. Barker was still...
What was that last part? What was their last bit there about? For those who were known...
Fairchild, the allocation of liability was between those who between them were known to have caused the disease.
Yes,
Between
I suppose so, yes. One of them did.
Yes, ma'am. Yeah, I accept that. Well,
I mean, that was the whole point of Fairchild, on the evidence, whether it's right or wrong, of course.
on the evidence,
It could have been one.
It could have been one. It could have been a combination of them. It could have been anything. But that's why I chose the words that.
Yes, no, I think you're right. Yes.
Barker was still concerned with exposures which between them caused the disease. And the additional element in Mr. Barker's case was the element of contrib and the question of whether or not that should disentitle him from relying upon the Fairchild exception. And it was commented, as I shall take the court to in a moment, by at least two of their lordships, namely Lord Roger and Lord Walker, that the balance of fairness was not nearly so clear-cut in such a case. It couldn't be said of any of the exposures of which were in issue in Barker that the mesothelioma would probably... Sorry, no, that's wrong. Now, if we move to the present position, my submission is that there is no compelling requirement of fairness which requires a claimant to be relieved of the need to show that his or her disease was actually caused by something other than the normal chances of everyday life. And it is in this context material to remember that Barker did extend Fairchild to cover the case where the claimant was contributory and negligent, but not by very far. Can I take the court to three excerpts? Can I take the court to paragraph 101, which is from my Lord Rogers' speech? My Lord is typically referred to as having dissented in Barker, and certainly your reasoning was opposed to that of the majority. But when it came to paragraph 101, and whether Mr. Barker should be within, well, can we just see what you said in paragraph 101? If the defendant's liability under the Fairchild exception had been in solidum, in my view, the potential injustice to a defendant in applying the exception in a case where the victim was solely responsible for a material exposure to asbestos dust would have been too great. That would be Mr. Barker. On that basis, I would have favoured applying the normal rule for proof of causation. The majority conclusion is, however, that a defendant's liable is to be several only. This involves such a major reduction in the scope of the defendant's liability that on that basis, I too would conclude that the balance of potential injustices favours applying the Fairchild exception. Now, that, with respect, was a clear balancing of fairness. It is largely reflected also in the reasoning of Lord Walker at paragraph 117. Where Lord Walker said, the injustice recognised in Fairchild of denying a claimant any remedy in a situation in which his or the deceased's fatal disease must have been caused by a breach of duty on the part of at least one of two or more employers, loses some of its edge if the disease might have been caused by the claimant or the deceased's own fault, or, as will become increasingly unlikely with the passage of time, by exposure to asbestos which, because public knowledge was deficient, did not involve any breach of duty by an employer or occupier, and without contributory negligence on the part of the claimant or the deceased. In that sort of situation, the possible injustice to the defendant assumes more importance. Nevertheless, if your lordships accept that the right way forward is to limit a defendant's liability by reference to its own contribution to the risk, the balance of fairness is still clearly, in my mind, in favour of applying the Fairchild principle to cases where less than 100% of the risk has been caused by employers or occupiers guilty of breaches of duty. So he too was premising his final decision on the fact that it was going to be apportioned liability rather than liability in solidum. I would submit in passing that he is clearly not contemplating any contribution from ambient exposure in that passage.
I mean, put ambient exposure aside, because I'm not myself quite sure that it's really as critical as your submission suggests. I mean, that passage from Lord Walker's speech suggests that at the very least there's got to be two or more negligent employers. And it further suggests that even then, if there's contributory negligence,
The balance shifts.
the balance may well shift it.
Yes.
And it's only because of apportionment that it doesn't.
Yes.
And now we're in a different ballgame because
Yes.
of Parliament's intervention. But, I mean, I'm not quite clear, I mean, are you contending that this case fails because there's only one candidate anyway?
Yes. Well, we have set that out we say this case is not, Sienkiewicz is not a Fairchild case because there's only one identified exposure to asbestos. That is central to our submissions, and it's in section 3 of our case.
But I mean, just say there'd been a second exposure to asbestos, but non-negligent by some other employer, Fairchild or not, in the light of the reversal of...
Yes. And may I simply complete my citation on this point?
Well, I'm not sure what the answer is to that. What is your answer?
I say two things. Ambient exposure was not contemplated and was not ruled upon in those cases. And the reasoning, there is no basis to extend the reasoning to ambient exposure. And any extension requires justification in this area. And I say that the doctrine was evidently, on the terms, intended to deal with the inability to choose between exposures extended to include contributory negligence in Barker.
Stuart Smith, supposing that you had an employer who was at fault, and you also had an exposure which had been caused because, let us say, a building had collapsed as a result of a landslide or an earthquake or something, which was nobody's fault. In that situation, would you say the Fairchild exception would apply? That's the thing. If anyone was still reading when the end of page 100, paragraph 170 in Fairchild, then you would have found a reference to natural occurrence. And that's what I had in mind with that situation. Now, would it apply in that kind of situation?
My Lord, I would submit that the better view would be that should be treated as a single exposure case, because you could still do the exercise of deciding whether probably...
Well, how could you? I mean
well, well, in a way, that answers the question. If you couldn't, then you would have to bring it into the Fairchild anyway.
Yes.
If you could, I say that the underlying justification for
So the
Fairchild
fact
is
that
gone
it's
anyway.
natural occurrence doesn't matter, just as it doesn't matter if it is a non-tortious act of a defendant. If there's two competing, it doesn't matter.
Well,
Isn't that right?
the submissions that I can make can live with occurrences like
Exactly.
that.
You're saying ambient doesn't count.
But ambient is not what I call an occurrence. And just because I would like to complete this point, having cited from Lord Roger and Lord Walker, I simply remind the court that my Lady Hale agreed with the reasoning of Lord Walker. So I submit that I've got something approaching a majority for this approach to the problem. And that encourages me to submit that, as I have been trying to do, that it has not been decided by the House of Lords that ambient exposure is or should be included. It is a matter for this court, which is open to this court to decide. Summarising my submissions, an extension requires justification, and there is no compelling justification or no justification at all for extending Fairchild to what I call a single exposure case, where the only other exposure is ambient.
I speak for myself, I found paragraph 128 of Lady Hale's speech rather helpful, and I'm not surprised you don't want us to look at that.
Well, I apologise for not having highlighted it and brought it to the attention of the court before.
Doesn't add anything, does it, to what others have said?
I couldn't possibly say that. I couldn't possibly say that.
May say it in shorter words, but then...
Yes.
Isn't your proposition slightly more fundamental? If there are only two possible causes of mesothelioma, and it's possible on balance of probability to identify which is the more probable, there's no need for Fairchild, no scope for Fairchild.
Exactly.
And ambient exposure normally will be disregarded because it's so small. It only becomes relevant if the competing exposure or exposures are very small as well. And then one asks oneself, can one adopt your basic approach? Here are two possible causes. Is it possible to identify one as being more probable than the other?
Yes. And I have not put it as elegantly as that, but that is issue one. Does Fairchild lay down a rule of law that in all mesothelioma cases it applies? I say no.
You'd say it doesn't apply if you can identify on balance of probability the cause.
Yes.
But if you say on balance of probability we can't identify the cause, but we can say it is one of A, B, C, or D, and those are all causes that flow from tortious conduct, then Fairchild says, well, those who between them or among them have caused it have got to share the responsibility.
Definitely. Yes. And my lord, that is a summary of the issue which we addressed in our case at the start of section 3, where we have gone through the various citations, which are now very well known in Fairchild and the passages, and we submit that it is absolutely clear that Fairchild and Barker both rest on impossibility of proof by conventional means. I was going to go through that section of my submissions, which are already in tatters, since I've gone way out of where I'd intended to go. But
That's almost inevitable in this court, I'm afraid.
I know that. I know that and expect it, but the constructive thing would be if I look at the bits that I've passed over and decide whether any of them actually need to be said, given where we now are.
But just to take that one step further, it is a question of fact then, isn't it? Whether it is possible in any given case
Yes.
to prove on the balance of probabilities which of the two
Yes.
is causative.
Yes. And my lord, on that, medical knowledge and science are advancing. At the time of Fairchild, the single fibre theory still held a degree of sway. We haven't put in Mr. Justice Burton's judgment in the trigger litigation. That is something which some members of this court may have the pleasure of looking at next year. But that was a 9-week trial which involved 2 weeks of listening to evidence not just from Dr. Rudd and Dr. Moore-Gillen, but also to biochemists and others as well. And the single fibre theory, the theory which holds that one fibre of asbestos on its own may cause the mesothelioma, period, is now not adhered to by any of the leading authorities. Individual fibres may have a part to play at various stages in the process, but the single fibre theory was a notion that even if you expose someone to one fibre only, that one fibre might have been the thing that killed on its own, killed the claimant, and that is not a theory which is maintained. And I don't say that in order to make a particular forensic point here, but simply to say that medical science is moving. And it may well be that although we are quite unable to discriminate between tortfeasors in a Fairchild type case at the moment, there may come a day when we can. And again, at the moment, I submit we have a distinction between the single exposure case and the multiple exposure case, because I'm presenting these appeals with an acceptance that the problem still does arise or can arise in multiple exposure cases, such as Fairchild, properly so called, or Barker. But in a single exposure case, it may be a question of fact. But I present the proposition that Fairchild certainly does not lay down a rule of law that it applies in all cases of mesothelioma.
So Fairchild applies if you're employed successively by two negligent employers, even if with the same level of exposure with each, but by one for 1 year, the other for 20 years, under Fairchild, they're both liable in full. Is that it?
Certainly, if Dr. Rudd was giving evidence to my lord, he would say yes, they should be, because he would say that at that level of exposure, if it's of itself material, 1 year, 5% cannot be dismissed as immaterial. So he would say, undoubtedly, that it is material and that you cannot determine which was right.
Well, I don't follow that. If you've only got two defendants in the fray, and there's no suggestion of any other cause, and one contributed 5% to the explosion, the other 95%, you start off on bounds of probability, one or other of them, and then you can break that down and say, on bounds of probability, it's the 95% one. The problem arises where you can't say that on balance of probability, it's any individual.
Yes, but it is undoubtedly the case with mesothelioma that the Fairchild problem is not simply constrained. It does not simply arise where you've got 5 people all contributing 20%. And it is a function of randomness. It is a function of randomness that I do not fully understand. It is at this stage that people start talking about black cabs and blue cabs and various other things like that. It is apparently a well-known example that if in a city, wherever it may be, there are 25 black cabs and 75 blue cabs, and you are hit by a cab, it is not more probable in a statistical sense that you have been hit by a blue cab. I find that, every time I come to these cases, I find that an impossible concept to understand. I was rather frightened that my Lord Phillips was going to do a Greg and Scott on me and tell me what the answer was, and I still wouldn't understand it. But so I'm rather relieved by your intervention. But what I live with, and the basis upon which I make my submissions, is that there are, in multiple exposure cases, apparently, it is not possible to come to a conclusion on the balance of probabilities simply in the way that my Lord Phillips and my Lord Brown has suggested. And for my part, in presenting these appeals, I accept that as fact.
That's because there's no direct correlation between the level of exposure and the onset of the condition.
Well, there is
No direct, I emphasize.
no direct, if I have my Lord's meaning correctly, yes. The level of exposure correlates to increase of risk, can be correlated to increase of risk, but further than that, it is said one cannot go.
That sounds like a nonsense, doesn't it?
Yes.
If the risk increases, then one would have thought that
My Lord,
the consequence is that on balance of probability, where the greatest risk lay, there is the greatest likelihood that the cause lies.
but it is undoubtedly to do with the concept of randomness. In a disease where it is still acknowledged that the etiology is not fully understood, and I take that as a given and do not seek to depart from it.
And there are gestational factors in play also, are there not, in the diagnosis of mesothelioma? The condition can lie quiescent for many years.
The condition
Or
itself,
at least not the condition, not the
there may
condition
be
of mesothelioma.
a period of latency for many years before you achieve frank malignancy. And no one can identify in the period before malignancy, the first malignant cell, no one can identify where you are in the process. It is thought to be a multi-stage process, but you cannot identify because you cannot see it. And indeed, it is one of the problems with mesothelioma that it never reveals itself until very late on in a person's life.
There are ample examples, are there not, of an exposure predating the diagnosis of mesothelioma by many years.
Oh, many years. 40 years is not uncommon. There are, if one takes, as it were, a typical outline, it is thought that the onset of malignancy will typically be about 10 years before the disease reveals itself. There will then be something between 18 months and possibly longer, depending on the progress of the disease, before the person dies. But if you take as your starting point the onset of malignancy, anything up to 40, 50 years before. And of course, it cannot be known whether it's even longer. It's just that not many cases can have a latency of longer than that because people die of other causes first.
That's really what's caused all the problems with insurance and so on, isn't it? Because they emerge many, many years later.
And Madam, we have brought copies of the Court of Appeal's judgment in the trigger litigation, which is now on its way here. But
this is the one they gave last week. Lord
Yes.
Justice Ricks gave the lead, and they gave leave themselves.
They gave leave. But having reviewed it again in the last couple of days, I don't propose, I think, to take you to it, except conceivably on one small point. Can I illustrate the difficulty that is faced in giving meaning to the phrase material increase in risk by looking at the terms of the evidence that was given by Dr. Rudd in the case of Willmore? Because my submission is that illustrates the complete elasticity and the need for some further guidance, and you find that in the Willmore Appendix, tab 7, page 61.
Willmore Appendix.
Page 61 comes from Dr. Rudd's first report, and this was at a time when it was thought that she had sustained mesothelioma as a consequence of playing amongst demolished buildings.
Is this a report of the 23rd of January 2008?
23rd of January 2008, yes, my lord. It starts on page 57, and at the bottom of page 61, he has a section called Causation of the Mesothelioma, where he says, general comments, mesothelioma is a rare tumour in persons who have not been exposed to asbestos, occurring with an annual incidence of around 1 million population, and most cases occur in persons who have been so exposed. Occasional spontaneous cases unrelated to asbestos exposure do occur, however. When there is a history of past asbestos exposure, the balance of probabilities strongly favours that exposure having been responsible for a mesothelioma which occurs subsequently. Then over the page, the first full paragraph, mesothelioma can occur after low-level asbestos exposure, and there is no threshold dose of asbestos below which there is no risk. However, the risk that mesothelioma will occur increases in proportion to the dose of asbestos received, and successive periods of exposure each augment the risk that mesothelioma will occur. He then refers to the long latent interval, which I was dealing with my Lord Kerr a moment ago, and then the paragraph, mesothelioma probably begins to grow about 10 years on average before clinical manifestations appear. All employments involving asbestos exposure up to the point at which growth of the tumour may be presumed to have commenced, i.e. about 10 years on average before the onset of clinical manifestations, will have contributed to the risk that mesothelioma would develop. The mechanisms of causation are incompletely understood. Thus, all exposure which contributed to the risk that mesothelioma would occur should be regarded as having contributed to causation of the mesothelioma.
Well, that's not a proposition for an expert witness.
My Lord, my submission was going to be, what I have written below that is apparently legal submission.
Yeah.
And we have another one coming. In the medical records, it's repeatedly been noted that asbestos exposure was thought to have been occurred when she was working in a shop, and so on. On the basis, the last 3 lines of that paragraph, on the basis of her evidence, there is not a sufficient basis on which to conclude that this employment materially increased the risk that she would develop mesothelioma. That, I submit, is another legal construct. Mm. She suspects that she was exposed to asbestos dust when playing on rubble. And then on the last paragraph, on the basis of her evidence to the effect that she played regularly during 2 summers among rubble, which included asbestos, I conclude that the circumstances described materially increased the risk that she would develop mesothelioma. So, because there is no threshold, it is, of course, technically accurate to say that any exposure contributes to risk. But what one sees here is a confusion of medical and legal concepts with no definition of materiality, because all exposure is treated as material, and no assessment of relative or absolute increase in risk from individual exposure. And my Lord, he then produced another report which starts at page 65. And at this stage, the claimant's case was that her exposure may have been on the buildings or may have been at school, and her expert thought that it was probably not while working in the shops. And my Lord, the court sees on page 66 my conclusions, it will be a matter for the court to determine on the basis of evidence presented by witnesses and consultant engineers from which source or sources Mrs. Willmore sustained significant exposure, where significant is defined in accordance with the definition adopted in relation to mesothelioma causation by the Industrial Injuries Advisory Council in 1996, a level above that commonly found in the air in buildings and the general outdoor environment. It would be appropriate for the court to conclude that each such exposure materially increased the risk that she would develop mesothelioma. So here one has a definition of significant as being any increase at all above ambient levels in circumstances where we know that the risk is proportionate to the dose, and therefore there should be some concept of de minimis, both in medical, scientific and legal terms. And my submission is that the last sentence we've just looked at, it would be appropriate for the court to conclude that each such exposure materially increased the risk that she would develop mesothelioma, is really meaningless and self-defining statement of legal rather than medical finding. Because, as is apparent, it is for the court to decide and not Dr. Rudd what is significant or material in law. He then, on page 87, responded to some questions which were based on the forms that Mrs. Willmore had filled out in order to obtain a grant under the Act, which referred to asbestos at the Army and Navy stores. And in line 3, Dr. Rudd said, the mere presence of asbestos in the pipes and in the storeroom would not necessarily result in her inhaling airborne asbestos dust. If the asbestos was damaged in such a way as to release dust into the environment, it is possible that she could have inhaled significant quantities of asbestos, and if she had done so, such exposure would have materially increased the risk that she would develop mesothelioma. And my Lord, it is, lest it be said otherwise, it is clear, certainly in the context of these appeals, that Dr. Rudd does accept that there is a de minimis level, and we see that from an exchange with counsel between Mr. Justice Nicholl and counsel, which is under tab 8 of the appendix at page 189.
We haven't got these tabs, but it doesn't matter.
I'm so sorry. But it is at page 189. Mr. Allen had previously said that it had been agreed that it would not be sufficient if there was simply one isolated occurrence described by the claimant in her evidence. And the judge picked that up on page 189, just above letter G. I then go back to what you were saying about the claimant's evidence, recalling that she went past on one occasion when there were workmen there. On that basis, that is not enough. And I hope, my lords, that the court's comments have the word not written in.
No.
No.
Well, it should have the word not written in.
Yes, it is here.
Oh, you've got it. It's a fairly critical not. And there's another change to make, because the next answer is not from Mr. Feeney, but from Mr. Allen, we believe. If there were simply workmen there. Mr. Justice Nicholl, if there were workmen there displacing tiles, but you seem to think that that was not. Mr. Allen, I'm not suggesting that is enough either in relation to breach or causation, because I know from other cases that Dr. Rudd would not suggest that created a significant exposure. I'm trying to struggle with this. What is the boundary? The boundary is if on a number of occasions the claimant passed in proximity to workmen who were undertaking activities with tiles which would have generated dust, then that would satisfy both the requirement for breach of duty and causation. A phrase like that, and the judge picked up a number of occasions. And possibly to save myself taking you to it again later, towards the bottom of the page, G, it is more a matter of impression. If the evidence had been, which it is not, that the claimant could recall an occasion when, as she walked along the corridor, dust fell upon her from the sawing of tiles that was going on, that would be sufficient of itself. That is not the evidence. That is not the evidence. No. But her description, which does not describe dust falling on her, and does not describe an activity such as sawing, which would give off large amounts of dust, that I accept is not sufficient. So, but that I use to illustrate the problem of a lack of precision or any definition at all, or any guidance as to what is meant or how to apply the legal concepts of material increase of risk in a concept where it is being said that any single fibre creates an increment of risk, although however small. As part of my preliminary submissions, before getting sucked into the material that we've been on already, I was going to submit and illustrate that the assessment of rates and quantity of exposure is nothing new, and it is an entirely conventional exercise carried out by claimants and defendants. I don't know that I need to take you to these references, but can I just tell you, in the case of Shortell, which is in your bundles at bundle AB, bundle 2, tab 20, at paragraph 5, Mr. Justice Mackay records that a Mr. Deary, who was the expert claimant in that case, or an expert in that case.
Very true. Tab 20.
It's bundle, authority bundle 2, tab 20. At page 562 of the bundle, paragraph 5 of the judgment, Mr. Justice Mackay was outlining the evidence that had been produced on the level of exposure, and he says that the claimant's called Peter Deary, and the court will see 5 lines from the bottom. From 1989, he's practiced in a consultant capacity and has prepared over 3,000 forensic reports in cases involving asbestos, in the course of which he has done hundreds of dose calculations. It so happens that Mr. Deary acted for the claimant in the case of Jones against Metal Box, which was the decision of Mr. His Honour Judge Hickenbottom, as he then was, which is tab 11 in bundle 1. I simply note the fact that he was acting for the claimant in that case. I don't take you to Jones at this stage. Sometimes, of course, it may not be possible. And Novartis was such a case, which is in bundle 1 at tab 16. This was a case about carcinoma of the bladder, alleged to be caused by exposure to asbestos. The reason I take the court to it at this stage is that in the judgment of Lady Justice Smith at paragraph 42 on page 462, oh, sorry, no, it wasn't asbestos. Nothing to do with asbestos at all. Paragraph 42, it is true that the judgment did not contain a quantitative analysis of the extent of the respondent's exposure. In my view, that was because the material was not available to permit such analysis. So the Court of Appeal, recognising there that it would be entirely conventional for there to be assessments of exposure, but that in some cases the material simply doesn't permit it. Equally, in my submission, the estimation of relative risk is a conventional exercise which is carried out both by claimants and defendants. And I mentioned earlier, I think, that it was adopted by Dr. Rudd in the case of Jones and Metal Box, which may we go to now. That is tab 11 in bundle 1. This was a mesothelioma case which the judge decided on the balance of probabilities, even though in his concluding paragraph he referred to increasing of risk. And may I take you, please, so that you can see that, to page 347 of the bundle, paragraph 52. At paragraph 52, the judge summarised the findings that he had previously made about the level of exposure, and then asks the question at the beginning of paragraph 53, on the balance of probabilities, did this increase in exposure to airborne chrysotile fibres at work cause her mesothelioma? This question is far from easy to answer, but having considered all of the evidence with particular care, I'm satisfied that it did, and I have taken into account the following. In subparagraph 1, he dismisses Dr. Gibbs's opinion that the mesothelioma was idiopathic. And at subparagraph 2, he says it was common ground that in order to succeed, the claimant must show that as a result of her exposure to asbestos dust at work, I've described Mrs. Jones's risk of mesothelioma at least doubled. That concession in the Cardiff County Court is not one that I would suggest binds this court. But he did say that, in my judgment, is a correct analysis of the position with regard to medical causation, because unless the claimant can show that the risk was doubled, then it is more likely than not that the mesothelioma had an idiopathic rather than an occupational cause. And by idiopathic, he had previously defined idiopathic as meaning that it is not attributable to any known specific asbestos exposure or other known cause, and that's at paragraph 46. And then at 3...
So the doubling is not with regard to ambient exposure, but just the risk of contracting mesothelioma without exposure at all.
That is the test that he applied.
Yes. There's a bit of a contradiction there. One talks about a level of ambient exposure, but imagine it's rather different in the Orkneys from Tyneside.
Yes, although two comments on that. Correct. 3. 2. One, in the paper by Pito and others, one of the interesting features is that they didn't find any significant variation in incidence between different health areas and health authorities, although they were spread around the country, which is possibly counterintuitive, because one would expect what my lord said about the Orkneys to be the same. Secondly, this was her only exposure, wasn't it?
It's quite complicated, actually.
Do you want to do this?
Do you want to come back to it later? Perhaps I can... Can I just explain?
Yes.
At that stage, Dr. Rudd did not distinguish between background exposure and what he called idiopathic. because he said you couldn't say whether a given case had been caused by the ambient background exposure or had arisen spontaneously. So for the purpose of this earlier case, it was a comparison between the occupational exposure and something called idiopathic, but which was including the ambient exposure as well.
Yes, thank you. But I imagine it's only, if there is ambient exposure everywhere, then it would only be a question of analysis on post-mortem and failure to find any fibres at all that might lead to the conclusion that this must be caused by something other than asbestos. But I don't know.
Well, there are a number of strands of the evidence, one of which is levels of exposure, one of which would be undoubtedly post-mortem findings, and it's one of the features of this case that the post-mortem findings in Sienkiewicz were consistent with ambient exposure. And there are no relevant post-mortem findings in the case of Willmore. So that doesn't, we don't have that area of evidence. But I mean, one of the comments that I'll try not to make more than once, and I hope I haven't made it already, is that this is, in one sense, a minority of cases does this arise at all. Because in most cases, defendants, it's simply not worth the candle to try and take the point, because the exposure is of a level where it would be a fruitless exercise. But going back to page 348, he extrapolated downwards from epidemiological data derived from large-scale research into Cristal miners and millers in Quebec. Mr. Feeney pointed out some difficulties with that, which were to do with the tremolite contamination of Cristal in Quebec. And Mr. Feeney took the point that the degree of extrapolation was very large, requiring reduction in exposure levels from Quebec workers to Mrs. Jones by a factor of several hundreds. And then, under subparagraph B, nevertheless, as Dr. Rudd put it, given the limited data and the practical impossibility of obtaining sensible epidemiological data in respect of a cohort of people relatively low exposures to Cristal, extrapolation down from the data that are available is the best that can be done despite the difficulties. And I am certainly not aware of Dr. Rudd having recanted in any way from his view that that is an appropriate exercise to be taken.
And is that the exercise you recommend in these cases?
Exactly. Well, where necessary. In those few cases where it's necessary. Yes. Yes.
Where you can't say, well, it's obvious that this is a real risk.
Yes. It will arise in cases, it will only arise in cases of very light exposure, and it will be for a defendant to take the point.
This all strikes me in a way as somewhat unrealistic. Somebody develops mesothelioma as a result, possibly, of exposure 20 years before. Who can possibly actually remember whether or not they were in a particular room at a particular time, if there was nothing to lodge it in their memory? The very fact that you've developed mesothelioma, it seems to me, would raise a strong presumption that you must have been exposed if there was a source of exposure in that building, quite regardless of whether you can ever remember it.
Yes. Well, that is very much the approach taken by Lord Justice Sedley, who takes the view that as soon as you have a mesothelioma, it leads ineluctably to a finding that it's caused by asbestos. But taking the first part of my Lord's question, it is, of course, there are difficulties of recollection over years, but it is surprising how much evidence is often available, certainly in cases of occupational exposure. Mrs. Sienkiewicz's case is a case in point. There were 15 witnesses, about 15 witnesses who had worked there, ranging from fellow employees to people who had been responsible for safety. I was always taught never to call the safety officer, but people do. And the corpus of evidence was really quite large and enabled the judge to make very specific findings of fact, as we see in his judgment in Sienkiewicz. he approached it with conspicuous care, as was recognised by the Court of Appeal, and made findings which cannot really be impeached. Now, it may be, I accept there may be cases where there is no recollection at all. In those cases, there may be no claim at all, because if there is no recollection at all, there may be nothing to attach. But once there is reason to attach, then the evidence has to be addressed, for better, for worse. It has been commented on before, my lord, that people are being asked to remember things from many years back, and it's very difficult. I don't know whether it would be convenient or helpful for the court at this stage or at all to look at the exercise that Dr. Jones did. The reason why I say I'm not sure whether it's helpful is that although I've read my learned friend Mr. Melton's case, which spends about 6 pages complaining about the exercise that was undertaken, at the end of it, as I read his case, he accepts that the findings were not perverse and could be made. And therefore, it seems to me that the precise detail of how Dr. Jones underwent his task may not be a good use of the court's time. And so if it is convenient to the court, what I would propose to do is not to go into the detail, to take you to his report and his evidence and cross-examination, but to deal with that in reply if it were to be necessary. Would that be convenient?
That sounds a very good idea. Thank you.
The next topic that I was going to deal with before coming on to the main issues, which I hope I can deal with certainly before the short adjournment, was observations on the development of material contribution as it has appeared, as it has been used in the highest courts over time, starting at Bonington and coming through. Now, to some of the court, this will be extraordinarily familiar territory, which it may not be helpful to go to, and so I would deal with it fairly quickly. And if what I'm doing is not helpful, I'm sure I will be stopped or hurried along. The problem only arises where you have multiple factors which may or may not contribute to the causation of an outcome. And the difficulty, as I submit, is that the phrase material contribution has been used in different contexts without ever really being defined except as being the obverse of de minimis. It may be convenient to divide cases into cases of divisible damage and indivisible damage. I can deal with divisible damage very quickly. Each factor which will be held responsible for the aliquot proportion of the whole damage which would not have occurred but for the contribution of that factor. And that's now Hornbook law. Asbestosis, Holtby, the cases Holtby, hearing loss, Smith's ship repairers. Pneumoconiosis is, as a matter of fact, essentially a divisible disease in that the severity of the outcome is dose-related. When we come to indivisible damage, my Lady Hale identified 2 cases in her speech in Barker. The first is where 2 factors operate independently, each of which is sufficient to cause the damage, and both the actors are held liable for the whole damage. So 2 people shoot bullets, both of which hit the person in the head, both of which would have killed. And this is from paragraph 122. The second...
Sorry, paragraph what?
Paragraph 122 of Barker, my lord.
Two people shoot.
2 people shoot. This is not the case where you don't know which of them is, where the person's only been hit by 1 bullet. This is where both bullets strike home. And paragraph 122 of Barker, which is page 615 of the report, and it's just above letter H, where two people acting independently shoot simultaneously and kill another, each is still liable for the whole, because there's no sensible basis for subdividing. The second case, which my lady refers to, is where joint tortfeasors act in concert, which is just above there at letter G. The owner of one of the two dogs which had worried the sheep was liable for the whole damage because each of the dogs did in law occasion the whole of the damage. That holds good, subject only to the contribution of one of the actors being de minimis, even though either factor on its own wouldn't have been enough to cause the whole damage. And then you have what is, in my submission, Wilshire, which is where you have two or more factors, each of which could be sufficient, but they operate in the alternative. And the factor which has operated will be liable for the whole damage, and the other will not, because it won't have operated. And that is Wilshire. When one comes to look at the provenance of material contribution, Bonington can be taken as a convenient starting point, which is in bundle 1 of the authorities at tab 3. And the feature of Bonington, which led naturally towards McGee, was that it was treated as an indivisible disease, where the two causes combined were sufficient to cause the injury. The court will know that the two sources were from the swing grinders and from the pneumatic hammers. And if we look for the statements of principle at page 621, at the top of the page, Lord Reid said the medical evidence was that pneumoconiosis is caused by a gradual accumulation in the lungs of minute particles of silica inhaled over a period of years. That means, I think, that the disease is caused by the whole of the noxious material inhaled, and if that material comes from two sources, it cannot be wholly attributed to material from one source or another. And then a little further down, about 5 lines further down, it appears to me that the source of his disease was the dust from both sources, and the real question is whether the dust from the swing grinders materially contributed to the disease, and that explains his response at the top of the next page, where he says, I think the position can be shortly stated in this way. It may be that of the noxious dust in the general atmosphere of the shop, more came from the pneumatic hammers than from the swing grinders, but I think it is sufficiently proved that the dust from the grinders made a substantial contribution, and in parenthesis I would add, to the whole, so that the disease is being treated as indivisible, and the dust from both swing grinders, or both sources, was necessary to cause the whole of the disease.
But I think you said earlier that pneumoconiosis is no longer regarded as indivisible.
And that's the puzzle. That's the puzzle. And it possibly accounts for some of the language in pneumoconiosis, in this and in Nicholson. But certainly, this was how Bonington was understood later, both by Lord Reid and Lord Wilberforce in McGee, and I'll come to that in a moment. Lord Tucker, at the bottom of page 623, is to the same effect. In my opinion, the inference to be drawn from these facts is that the silica dust discharged the swing grinders from the swing grinders contributed to the harmful condition of the atmosphere, which admittedly resulted in the pursuer contracting pneumoconiosis and was therefore a contributory cause of the disease. Lord Keith, at pages 626 to 627, is somewhat more equivocal. But he says about 8 lines from the bottom of page 626, which is page 82 in the bundle, no, about 10 lines, it was the atmosphere inhaled by the pursuer that caused his illness, and it is impossible in my opinion, to resolve the components of that atmosphere into particles caused by the fault of the defenders and particles not caused by the fault of the defenders, as if they were separate and independent factors in his illness. Prima facie, the particles inhaled are acting cumulatively, and I think the natural inference is that had it not been for the cumulative effect, the pursuer would not have developed pneumoconiosis when he did, and might not have developed it at all. So my suggestion is that is the language of indivisible disease.
Indivisible but cumulative.
Caused by an aggregation, yes, you needed the cumulative effect of all the dust to cause the disease. And that is why a source which makes a more than minimal contribution to the whole is held liable for the whole of the damage. Nicholson is in bundle 1 at tab 15. And my overall submission is that although pneumoconiosis is here described as a disease of gradual onset, as we shall see, and a progressive disease, there's no analysis of whether the contribution of the tortious exposure was to the contribution of an indivisible disease or worsening a divisible disease, but the result means that it was treated as a case like Bonington and as an indivisible disease. And in Nicholson, at page 620 of the report, which is page 442 of the bundle, Viscount Simmons, at the top of the page, imposes liability on the basis of an increase in risk. He says, having said that better ventilation and improved roof ventilators were practicable, he says at the end of the second line, it follows that owing to the default of the respondents, the deceased was exposed to a greater degree of risk than he should have been, and though it is impossible even approximately to quantify the particles which he must in any event have inhaled, and those which he inhaled but need not have, I cannot regard the excess as something so negligible that the maxim de minimis is applicable. Accordingly, following the decision in Wardlell's case, I must hold the respondents liable. By Lord Cohen at page 622, 2 pages on, paragraph in the middle of the page, as we shall see, describes pneumoconiosis as an infectious disease, but he also, at the start of the paragraph, says pneumoconiosis is a progressive disease. The longer a workman is exposed to an intense cloud, the graver must be the risk of infection. In the present case, it is clearly established by the evidence that down to 1949, the tool with which the deceased was working on dirty castings created a thick cloud of dust. The respondents are admittedly not to blame for the generation of this cloud, but any failure to provide proper ventilation must, I think, lengthen the period during which the cloud remains intense. It seems to me to follow that the respondents' failure to provide adequate ventilation must increase the risk to which the workmen are exposed. Reading the evidence as a whole, I think it establishes, to use the language of Lord Reid in Wardlell's case, on the balance of probabilities, the breach of duty caused or materially contributed to the injury. So he is not finding on the basis of risk. And without any significant further analysis, at page 627, which is page 449 of the bundle, about a third of the way down, he refers to the lack of ventilators and says in a sentence starting about 15 lines down, it would necessarily reduce the density of the dust which is proved in the evidence to have hung about and which was produced not only by the deceased pneumatic hammer, but from the other buffing and cleansing operations going on around him. It would also reduce the amount that was allowed to settle on the floor and equipment which could be stirred up again by any draught or other disturbance. Thus, the cumulative amount of dust inhaled by the deceased would have been appreciably diminished, and for the reasons given in Bonington, the pursuers here would be entitled to succeed. So he simply appears to follow Bonington and treat it as a case on all fours with Bonington. I don't, although we have it in the bundle, I don't take you to the House of Lords decision in Gardiner because although at first instance Lord Kilbrandon, it's at tab 8, although at first instance Lord Kilbrandon had referred to increase in risk, the House of Lords all treated this as a simple case of proof on the balance of probabilities, and there is no mention in Gardiner in the House of Lords of material contribution. It's also possibly remarkable in being a decision of the House of Lords in which no authority is cited at all.
Seems to be an extempore judgment.
I think possibly not. Because
Says their lordships took time for consideration.
I think they took.
Oh no, they did take
July the 6th. Was
That's
it?
Oh no, sorry, no, I'm terrible. I got
I think they took time to
the
dispense.
dates. The dates on the front page are not the date of the judgment.
No. They took time to dispense with authority, I think, possibly. So it is McGee which, as has been recognised, carried out the transformation from material contribution to injury to material contribution to risk. But in McGee, there is no further definition of what material might mean either in the new context of contribution to risk or previously in relation to injury. Can I pick up those references when I now move to my primary submission, which is that the Fairchild exception does not apply to all mesotheliomas and requires as a prerequisite impossibility of proof. In our case, at page 6, we set out the now very familiar citations from Fairchild. And Fairchild itself is at tab 7 of the authorities bundle. On page 6, we set out the passage from paragraph 2 of Lord Bingham's speech, where, as his sixth feature of the cases then being considered, he said it was that any cause of the claimant, or number 5, any cause of the claimant's mesothelioma other than the inhalation of asbestos dust at work can be effectively discounted. But 6, the claimant cannot, because of the current limits of human science, prove on the balance of probabilities that his mesothelioma was the result of his inhaling asbestos dust during his employment by A, or during his employment by B, or during his employment by A and B taken together. And at paragraph 7,
What's the alternative cause in the last of those possibilities, or during his employment by A and B taken together? That seems to postulate that the only employers responsible for any exposure were A and B, and yet it can't be proved as a matter of probability that it was A and B taken together. What else is Lord Bingham, what else could the cause be?
I think what he is doing is outlining the theoretical possibilities that it's A's exposure or B's exposure or A and B's exposure taken together, and is saying that medical science cannot say which of those three alternatives it may be.
I know, but I mean, if it isn't, if it can't be shown, I see, you think it's just simply going to which of them it is,
Yes.
rather than the possibility that it might be something completely different. Yeah.
Yes, and that I think so that becomes also clear when one goes to paragraph 7
Yes.
with the passage about the rock of uncertainty.
He would be thinking perhaps of the case where you had several employers, not only, but the only two you could bring into court were B and C.
Yes.
It might have been D as well, so you couldn't show that it was B and C because it might have been D.
That I certainly accept. I
think that's the kind of thing, because that was the kind of situation, I think, which really was in the background in Fairchild, if I'm not wrong. Because part of the argument was it's terribly unfair because there are all sorts of other people who were employers and so on, but who are now dissolved and so on, or uninsured. Wasn't that part of it? Or whom one didn't know?
That is certainly was part of the argument.
I think
I wasn't here.
No,
for
but I
that.
think that was part of it.
But I had always taken, perhaps wrongly, as I wasn't here, paragraph 2 as Lord Bingham characteristically reducing the problem to its minimal necessary terms and just dealing with A and B.
Lord Roger's explanation makes better sense, doesn't it? Because if he'd meant what you suggest, there would have been the word whether rather than that. Whether his mesothelioma rather than that.
Yes, but to the opposite effect, if one looks at the beginning of this passage, he starts it by saying if C was employed at different times and for different periods by both A and B. So he appears to be taking possibly a model. It doesn't matter because the Fairchild problem exists if D, E and F existed but were not before the court.
He's taking, I mean, the model of you've got tortious exposure from more than one defendant, and it is entirely possible that one of them is entirely innocent of causing the mesothelioma. That's the problem he's setting out, isn't it?
That's the problem, because that's where the potential unfairness comes, on which he then...
both. Or both.
They both could be, yeah.
So 3 is that both are in breach of duty.
Yeah, but,
Yes.
Well, certainly, if D, E and F
But
are not before the court, then
innocent
A
of
and B
causing
may
it.
both have a gripe.
absolutely.
Yes,
But-
absolutely.
Innocent of causing it.
Yes.
They're in breach of duty, but innocent of causing it.
Yes.
The paragraph 7 of his speech, he then outlines what is known and not known about mesothelioma. And can I pick it up just below, just above letter D, where he's referred to the various genetic changes. And he says, asbestos acts in at least one of these stages and may, but this is uncertain, act in more than one. It is not known what level of exposure to asbestos dust and fibre can be tolerated without significant risk of developing the mesothelioma, but it is known that those living in urban environments, although without occupational exposure, inhale large numbers of asbestos fibres without developing the mesothelioma. So ambient exposure wasn't utterly off the radar in Fairchild. It is accepted that the risk of developing a mesothelioma increases in proportion to the quantity of asbestos dust and fibres inhaled. The greater the quantity of dust and fibre inhaled, the greater the risk, but the condition may be caused by a single fibre, or a few fibres, or many fibres. That may need to be qualified now. Medical opinion holds none of these possibilities to be more probable than any other, and the condition once caused is not aggravated by further exposure. So if C is employed successively by A and B, and is exposed to asbestos dust and fibres during each employment and develops a mesothelioma, the very strong probability is that this would have been caused by inhalation of asbestos dust containing fibres, but C could have inhaled a single fibre giving rise to his condition during employment by A, in which case his exposure by B will have no effect on his condition, or he could have inhaled a single fibre giving rise to his condition during his employment by B, in which case his exposure by A will have no effect. This is the point that my Lady Hale was on a moment ago. And then he says, there is no way of identifying, even on a balance of probabilities, the source of the fibre or fibres which initiated the genetic process, which culminated in the malignant tumour. It's on this rock of uncertainty, reflecting the point to which medical science has so far advanced.
Can I just come back to that? Because
yes.
I have great difficulty with it as a proposition of logic. I can see if the period of exposure was more or less the same with A and B. But if you postulate that the greater the exposure, the greater the risk, and you have 5 times as much exposure with A than with B, and you then say on balance of probability, was it A or was it B, or a combination of the two? I'd have thought logic would say, well, the exposure with A was so much greater, the risk caused by A was so much greater than the additional risk caused by B. So on balance of probabilities, the cause was probably A's exposure. I mean,
I too, my lord, as I think I've made clear,
yes,
have extraordinary difficulty with this. But interestingly enough, when we were on this topic about an hour ago,
yes,
and your brow and my Lord
yes,
Brown's brows were furrowing, my Lord Roger was nodding
yes,
sagely. So I think possibly he thinks he understands what I certainly don't.
There's not in the adjournment.
I merely accept what I am told.
Well, my lord, that's my position too. I'm told, and this appeal is not intended to subvert that assumption. What this appeal is to say is if there are cases where it is not impossible, does Fairchild still apply? And we submit that the answer should be absolutely clear.
Where does it appear from Lord Bingham's speech that he contemplated innocent employment, C or D&E? I can't find it.
No, he didn't.
No.
The only thing that can be said is that he did mention the fact that we all inhale asbestos in the course of his
but that aside, he was on the face of it contemplating that certainly the risk came from those defendants who were before the court.
And
have been negligent.
yes, and I think it would be fair to say that Barker was conducted essentially on that basis that Fairchild had been a case where all exposure had been tortious.
Yeah.
Because one of the arguments that I know I advanced in Barker was that it's fair enough to impose liability like that when you know that everybody's been tortious, but otherwise you go too far. So it is, I think, very well known that at paragraph 34, Lord Bingham held that the exception would apply where his 6 factors were in place, and that included the impossibility of proof on conventional principles. Lord Nichols was to the same effect at paragraph 41. Where at line 3, he said, inhalation of asbestos dust carries a risk of mesothelioma. That is one of the very risks from which the employer's duty of care is intended to protect employees. Tragically, each claimant acquired this fatal disease from a wrongful exposure to asbestos dust in the course of his employment. a former employee's inability to identify which particular period of wrongful exposure brought about the onset of his disease ought not in all justice to preclude recovery of compensation. So that was the bedrock upon which he founded. At paragraph 43, he made clear that this was exceptional and that the mere fact that a claimant has difficulty in discharging the burden of proof that's placed on him isn't enough. Can I take you to that? I need hardly add that considerable restraint is called for in any relaxation of the threshold but-for test of causal causation. The principle that's applied on these appeals is emphatically not intended to lead to such a relaxation whenever a plaintiff has difficulty, perhaps understandable difficulty, in discharging the burden of proof resting on him. Unless closely confined in its application, this principle could become a source of injustice to defendants. There must be good reason for departing from the normal threshold but-for test. The reason must be sufficiently weighty to justify depriving the defendant of protection, and so on. Lord Hoffman, at paragraphs 61 to 62, at paragraph 61, he identified what he regarded as the significant features of the case, of which the fourth one, just below letter D, was fourthly, except in the case in which there has been only one significant exposure to asbestos, medical science cannot prove whose asbestos is more likely than not to have produced the cell mutation again, which caused the disease. And then 62, in those circumstances, a rule requiring proof of a link between the defendant's asbestos and the claimant's disease would, with the arbitrary exception of single employer cases, empty the duty of content. Lord Hutton, as I think is well known, adopted a different approach to McGee, but he still saw impossibility of conventional proof as being the root of the problem, and we see that at paragraph 108. After his review of McGee at 108, he says, therefore, whilst the decision taken by the House in McGee may have been based on an inference of fact, I consider that it is in the interests of justice that it should now be held as a matter of law that the approach taken by the House in McGee is one which should be followed by trial judges in cases such as the present ones, where the claimant can prove that the employer's breach of duty materially increased the risk of him contracting a particular disease and the disease occurred, but where in the state of existing medical knowledge, he is unable to prove by medical evidence that the breach was the cause of the disease. And then, my Lord Roger, can I pick it up at paragraph 153? And if anyone thinks I've left out anything important, no doubt they'll tell me.
Is proved by medical evidence the same as proving on balanced probability, applying epidemiology or statistics, or is it something different?
It is proving on balance of probability. The epidemiological evidence often leads to taking non-specific probability as a proxy for specific proof of probability. So, for example, in my Lord Brown's case of Hodson, where it was said that by the time the boy got to the hospital, he was a 75% risk that he was going to suffer the avascular necrosis. And he was deprived of the 25% risk. That was a non-specific finding, because, not least because no one examined the boy appropriately to discover whether or not he could be, or his hip could be saved. And what was being done there, as in many other cases, was effectively to say, in 75% of cases such as this, or if you had 100 cases such as this, 75 of them would go on to a vascular necrosis and 25 didn't. And that was the basis upon which ultimately the House of Lords said, no, this leads to a finding on the balance of probabilities in this particular case that the vascular necrosis would have happened in any event.
But you couldn't say that was the medical evidence.
Well,
The doctor or whatever carrying out post-mortem would say, I can't tell you, I'm afraid. I can't tell you which it was.
particularly where he didn't examine the child at the critical moment.
Yes.
And so one is inevitably thrown back on broader probabilities. And there's nothing unconventional about that. I hope this afternoon taking you to some references from other jurisdictions where the same approach is adopted, just to show that it's conventional elsewhere as well. But my submission is that it is now entirely conventional to extrapolate from the general to the particular, while knowing perfectly well that the general was not particular in that way.
It may not be relevant, but and it's probably a matter that Lord Brown is better qualified to comment on than I am, but I didn't understand Hodson in that way. I thought that what the medical evidence said was nobody examined him at the time. There is I can say with 75% certainty of proof that the boy had already suffered the injury to his leg, or whatever it was, which doomed the leg. And that's different from saying that there's a 75% risk that someone in his condition would subsequently develop some future problem. It was a 75% certainty that he already had the problem.
I will review it over the shorter journey, but that is not.
I mean, that's part of the trouble about talking about risk here. Sometimes one's talking about a risk of something in the future occurring.
Absolutely.
Sometimes one's actually talking about
The chance that it has occurred.
yes, the degree of certainty of the proof.
And of course, the law adopts different approaches for things that have happened and things in the future and so on.
Yes.
But it is not just a private bugbear of mine, but it is a feature of our law that we are quite imprecise in the way that we approach and adopt the use of statistics. And my Lord Phillips's speech in Gregg and Scott lays that bare, because we are all. It's almost the same as when a counsel is asked prospects on a case, and time and again one is asked, well, can you give me a percentage? Well, what does it mean when you say, well, you've got 70% chances of success? What it means is, I think you're going to win, and I think it's fairly robust. How much do you have to take away before you lose? And in a way, the same problem permeates the use of statistics in the decision-making process of the courts. Can I go to paragraph 153 of Fairchild? And would it be convenient if I just finish the citation from Lord Roger's speech before the adjournment? Paragraph 153, just below letter H, 3 lines from the bottom. The important point is that in both cases, the state of scientific knowledge makes it impossible for the victim to prove on the balance of probabilities that his injury was caused by the defenders or the defendant's wrongdoing, rather than by the events of similar nature, which would not constitute on wrongdoing on their part. And then you extrapolate from McGee and say that's almost a fortiori. And while I'm here, can I just pick up a comment in paragraph 155, just above letter G. In these circumstances, one might think in dubio the law should favour the claimants. Moreover, in McGee, the House did nothing more than set the requirement of proof at the highest that the pursuer could possibly attain, hardly a relaxation in any real sense. He had proved all that he could and had established that the defender's wrongdoing had put him to a risk of the very kind of injury that befell him. To require more would have been to say that he would never recover for his injury. And then, after referring to Rutherford, which we'll come to probably later today, at paragraphs 168 to 170, my Lord came to the conclusion of his speech, and in paragraph 170 gave some criteria which were to be satisfied and were satisfied in the present case. And 3 lines, starting at the top of paragraph 170, the principle is designed to resolve the difficulty that arises where it is inherently impossible for the claimant to prove exactly how his injury was caused. It applies, therefore, where the claimant has proved all that he possibly can, but the causal link could only ever be established by scientific investigation, and the current state of relevant science leaves it uncertain exactly how the injury was caused, and so who caused it. So, my Lord, we've set out rather more of that paragraph in our case, but that concludes the citation from Fairchild.
Just going back to the point we were making, if you look at paragraph 123, 123, it just makes the point that we did have in mind, certainly I did, have in mind the fact that all that the pursuer had done here, or the claimant had done, was to sue those people the employers whom they could identify.
Yes.
It was people. I mean, people were well aware of the fact that there were other people. So it wasn't the case that you could say that the defendant, one of the defendants, must have been the person who caused it.
It certainly was a feature of cases before the Fairchild point was taken, was that people would look for a good target and would be satisfied with that. Would that be a convenient?
Yes, it would. We'll adjourn until 2 o'clock.
Thank you.